So, what happens to someone's car when they die in Florida? This comes up a lot, and the question, like with most assets, depends on the actual title ownership of the vehicle to begin with. So, if there was another owner that had survivorship rights right on that title, then most likely that person owns it outright. And this would be without referring to a will or a trust because it would happen by operation of law. If that's not the case, then it may be a probate asset that has to be dealt with, but there are exceptions, and there are times when you don't necessarily have to go through the court process to transfer the title. And that can be when there's an affidavit submitted to the Department of Motor Vehicles. So sometimes the survivors, the next of kin, can go to the DMV with a copy of a will and a death certificate and the registration or prior title, and just have the ownership transferred to the beneficiaries in that will or to the heirs at law directly. So that doesn't always work if there's a dispute or if there's creditors of the estate, but if this is the only asset you're dealing with, usually that's a good avenue to at least try. And another thing to know about the vehicle is that Florida treats up to two vehicles as exempt property, so long as they're under 1,500 pounds and they're regularly used as personal vehicles. They're protected from most creditors of the estate. So, who receives those depends on the family situation and who can take advantage of that exemption from creditors. Usually it's the surviving spouse, if there is one, or if there is no spouse, then the children can take ownership free from those creditors' claims. If you have questions about vehicles or vessels or other assets that may be going into probate, feel free to let us know and we'll see if we can help.